Statute of limitations are statutory limitations on the time period in which an individual has to bring a personal injury or a wrongful death claim. Statutes of limitations are designed to protect defendants from stale claims, when memories have faded and evidence has disappeared, and they basically have no way to defend these claims. So generally, by statute, we have periods in which a plaintiff must bring his claim or lose it forever. There are both state and federal statute of limitations. For maritime accidents that occur on a non-navigable waterway, such as on a lake that is landlocked within a state, the state statute of limitations will apply. Washington State has a 3-year statute of limitations on personal injury claims. Oregon has a 2-year statute of limitation. California has a 2-year statute of limitations. And Alaska has a 2-year statute of limitation for personal injury claims. Now, the only time we'll see these state statutes of limitations come into play are for recreational boating accidents that happen on landlocked lakes that aren't connected to rivers or to another state that are navigable for commercial purposes. There's a 3-year federal statute of limitations for maritime torts occurring on the navigable waters of the United States and the high seas. Now, just because you have a 3-year statutory limit, that doesn't mean that you're going to have 3 years in every situation. There is a 2-year statute of limitations if you intend to sue the federal government for an injury arising from an incident with a vessel that is owned by the United States. In addition to this shortened 2-year period, there are also notification requirements, written notice of claim. So we encourage you to seek counsel if you've been injured on a vessel owned by the United States. Oftentimes, if you're injured on a cruise ship or a sightseeing cruise, your cruise ticket provides a maritime contract between you and the common carrier. And those tickets may further limit the period you have to bring a claim. You have as little as 6 months for a written claim and 1 year to bring your lawsuit. So although we have a 3-year limit, we also have another statute that sets the minimums, and these are the minimum times that a common carrier can put in its contracts of passage, your ticket, for shortening these statutory periods. So if you're injured on a cruise ship or a sightseeing cruise or a charter boat when you're fishing, make sure to contact a maritime attorney that can advise you on this contract and the fine print that you may not be aware of, because it's not always 3 years despite this federal statute. Now, under the Jones Act, seamen have 3 years to bring their Jones Act negligence claim or their unseaworthiness claim. The maintenance and cure claim is governed by the doctrine of laches. Laches is an equitable doctrine that allows for a little bit more flexibility. Basically, the court will look at the analogous statute, but there'll be some leeway potentially in which the court will assess whether the delay in filing was excused and whether or not the defendant was prejudiced. Finally, for longshoremen that have claims against third parties or vessel negligence claims under Section 905B of the Longshore Act, they have 3 years as well. So these are typically a 3-year limitation period, but be careful, passengers on vessels, because your cruise ticket may well shorten this 3 years to as little as 1 year, with the prerequisite that at the 6-month mark, you file a written notice of claim, which is in essence is a letter informing them of what happened, what your injuries are, and that you intend to hold the common carrier liable.